Namaste, Sakshi Telugu Prajala Mana Sakshi Special Immigration Show ki Swagatam. Today we are back with our expert attorney Bhanu Babu Illindra garu, BBI Law Group PC, 17 years of experience in law offices. And if you have any questions regarding immigration, feel call to Priyas and our attorney will glad to answer your questions. So before we begin the show, please note that the information provided on this show not a legal advice. It's just for information purpose only. So Sakshi TV or its agents will not be responsible for this. If you need any specific legal advice, please contact the attorney directly. And today we are going to talk about H4E filings as registrations are completed and what to expect. Next, ఏం చేయాలని టాపిక్ మనం మాట్లాడుకోబోతున్నాం. సో భాను గారు రెడీగా ఉన్నారు. నమస్తే భాను గారు, వెల్కమ్ టు ది షో అండి.
Welcome. Thank you, Andy. Thank you, Prasanna garu. Thank you, Sakshi TV. Thanks for welcoming me again.
Yes, Bhanu garu, మనం టాపిక్ లోకి వెళ్లే ముందు లా ఆఫీసెస్ ఇన్ఫర్మేషన్ అండ్ ఆల్సో ప్రాక్టీస్ ఏరియాస్ గురించి వ్యూయర్స్ కి తెలియజేస్తారా?
Sure, madam. My name is Bhanu Babu Illindra, Andy. I'm an immigration attorney here. My law firm name is BBI Law Group PC. I've been practicing immigration law for 17 years. And I represent in all types of immigration matters, Andy. And employment-based immigration matters, family-based immigration matters, investor visa, all types of immigration matters pertaining to US laws. US immigration, I handle them basically. We also recently started handling outbound immigration cases also, like people going to different countries, not only just coming to the US basically, from the people from US who are going to India, or people are going to UK, Netherlands basically, or Germany. And we are basically even started those services also, helping them to get their immigration processing and everything. Even Canada also we started recently. So we should be able to help people with that also. Our firm website is www.bbilawgroup.com. Our office number is 703-496-7722. And my mobile number is 319-400-0053. And they can also reach me towards my email also. It's bhanu@bbilawgroup.com. Or they can visit our website www.bbilawgroup.com, where they can actually schedule an appointment from there. We are always available to them. Anytime they need anything else, we are there for that, Yeah.
Thanks for the info, Bhanu garu. Yes, before we get into the topic, manaki చాలా మంది కాలర్స్ క్వశ్చన్స్ తో రెడీగా ఉన్నారు. సో లెట్స్ టేక్ అవర్ ఫస్ట్ కాలర్ సన్నీ ఫ్రమ్ వాషింగ్టన్ DC. Sunny.
Hi, sir. Hello.
Yeah, hi, sir. Hi. So I have one question. So basically, I am from I did my second master's from University of Southern Mississippi. Sorry,
Okay.
University of Farmington.
Okay.
So I think you heard about University of Farmington, right? We have a big issue
I
a couple
do.
of years back.
I know the
Yeah.
story. Tell me.
So recently, basically, the time the issue come out, I was on H1B. Okay. Recently, I got the intent to revoke on my H1B. So because when I was filing, I was on that university, and they want to revoke my change of status from F1 to H1, and they want to go for stamping. That's what. So because no other attorney is coming forward to take up this case, and so what will be the solution for this?
Sir, unfortunately, I do not know there is any solution for this, but you should try. I mean, you should try to respond to the NOID or NOID, whatever they issued. You should respond to the explaining why your case should not be revoked, why it should not be impacted because of the Farmington issue, basically, And the whole problem here is the USCIS deems that everybody, whoever enrolled in that university, has knowingly enrolled into that university, that they don't have to attend any classes while they're enrolled as a full-time students in that particular college, because that college was established by the Department of Homeland Security itself as a sting operation. We all know that basically. So the chance
we know only after joining, right? Not before. Yeah.
Yes, but what the USCIS deems is what I'm trying to tell you, sir. I'm not saying that you intended to do anything wrong or not, but what I'm trying to say here is what USCIS deems of individuals basically who are enrolled into that program basically, because they know that they don't have to attend the classes. As everybody knows that who's on F1 visa here in this country, they have to register full-time classes and they have to attend in-person classes basically, They cannot do full-time. They're not considered full-time students if they're doing online programming at all, basically. And people who registered in the program clearly aware that they don't have to attend any classes, and that's the stance which USCIS is taking. If you have any evidence contrary to that, and if you can provide any evidence which is in contrary to that. It doesn't have to be clear and convincing also. Even an evidence that's probably more likely they're not going to create a doubt that what the stand US is taking is incorrect, then we should be able to get the approval for you. It should be no matter what. Point is that evidence has to be provided by you. Those facts can be provided by you. I would say is this, no matter what, whatever the situation is, basically is that you need to respond to that lawyer. Respond to the lawyer, explaining the facts truthfully and everything, and leave it to the discretion of the USCIS whether they would revoke your H1B or they will approve your H1B or not. And lawyer.
Okay, so what I got is like basically it's not H1B revoke, it's just a change of status revoke. Okay, from F1 to H1. So that means they're telling me like you have to go for stamping, right? In the background.
It is not the change of status revoke, sir. I mean, I do not know exactly what you have got. Usually, when they ask for the revocation, they will be saying the revocation of the entire H1B petition because the petition was obtained by misrepresentation of fraud for them about your maintenance of status in this country. So when they issue the notice of intent to revoke, it will be for the entire H1B petition, not just for the change of status. So, but if anything else is there in your notice of intent to revoke, I think you better contact me privately. I'm very happy to look into it and see basically what will be the cost and everything also for our services and able to assist you on that. Unfortunately, there are several students who are under your situation basically who have been enrolled in Farmington, unfortunately,
Yes, right. Thanks for calling. We have next caller, Sai from Nashville. Sai, please go on.
Hello. Thanks for giving me this opportunity. I have a question. So I moved from employee A to employee B. I have an I-140 approved for more than a year from the employee A. So the employee B is saying that he's going to file my green card process and it would take 2 years. So my question to you is that if my priority date is 2016 and I'm in EB3, so if the dates move and I'm still with employee B itself and the date of final action or the date of filing becomes dates moving, so what are my options? My question is, after the dates have moved, dates have become current, after my I-140 is approved, so will USCIS, if I file, they will give me my GC?
Sir, basically, the employment-based immigration is an employer-specific immigration. What does that mean is basically is that if your employer A is intending to continue your green card, even after you move to employer B, and if they don't revoke your I-140, and if they allow you to file 485, once the dates become current, it's well and good. You should be able to file for adjustment of status if the date become current, whether it's a final action date, or if the USCIS allows you, if the filing dates comes in current, and then if the USCIS allows you to file adjustment of status based upon the filing dates in the visa bulletin, then you should be able to file adjustment of status application. You just can't move to the employer B and then file 485 when the date's current with this one. When you are not working with the employer A without the consent of the employer A, because employer A has to provide his consent in the form of I-485J supplement to you, basically, and only the way that you will be able to retain that priority date for any future I-140 petitions being filed. As you said, your employer B I-140 petition, they're going to take 2 years to get you a green card, basically. But that I-140 petition will retain the priority date of 2016, which was approved with employer A for you, basically. So the facts, what you are telling me is, this is what I'm understanding with what you are telling me, that you wanted to file 485 based upon that I-140 without even knowledge of the employer A. No. That is not possible. Unfortunately, that is not possible.
No, I got the point. Okay, here is my another question. So the final action date becomes current, and I'm still with my employer B, and employer B I-140 got approved after 6 months after the dates have moved. So will if the employer B files for me for a GC, will I get it? Since already
You will get it. Everybody has to get it, sir. That's what the process is all about. If they file your I-140, basically, and if the dates are current, while I-140 is pending, you should be able to file your 485 also. It's called concurrent filing. It doesn't mean that your I-140 has to be approved to file 485. While I-140 is pending, you should be able to file 485 with that employer. Once I-140 is approved, once they adjudicate your 485, and if the provided dates are current at the time your 485 is adjudicated, then you'll get a green card. Absolutely. And provided you meet all the requirements for the green card.
Manugar, we have another caller, Srinath from Virginia. Srinath, please go on.
Hello, Bhanu. My question, Andy. Recently, in the month of October 2020, I filed my 485. So, I think you are aware of that. After filing 485 in the month of October, many people got rejection. You must be aware of that. So what happened? What happened is these rejections happened. Out of these rejections, 90% of the rejections are derivative applicants got rejected. Remaining 8 to 10% primary applicants got rejected. So what's happening is now after that, people after getting rejections, everyone getting refiling. So now what I realize is now USCIS accepting refiling of the derivative applications only. If first filing primary and if automatically, I think if primary get rejected, automatically derivative also get rejected. So if they refile again, primary and derivative both, they are not accepting. But only derivatives are accepting.
Is it your experience what you're saying, sir? Or do you have a concrete proof for that?
I have a concrete proof of that. Around 15 to 20 last 1 week, I have around 20 derivative applications got accepted, and around 12 to 15 primary and derivative. Those applied primary plus derivative resubmitted, they got rejected.
So I think yeah, tell me, sir.
No, go ahead. I'm good.
No, you're saying something, sir. I'm listening.
No, what I'm saying is why this discrimination? Like basically, these rejections happen because of the leaving one question blank, either in the primary and derivative. So derivative is 90% of the rejections, one question leaving blank that got rejected, that is true. They are resubmitting that question and they are accepting. If any question left blank in the primary that got rejected, but when they are correcting and sending back, it is not getting accepted. Why this discrimination between primary and derivative? Is the error is error. This is basically done by attorneys, not to the applicants. Completely well experienced, all the attorneys done this mistake. It is not applicant nor anything done. It is well educated and well experienced attorneys without, I don't know whether knowingly, unknowingly, whether can read the questions or not, I don't know. They left some question, one question in some derivative and primary, and it got rejected. And they,
sir,
I'm worried. My question
I have one question to you, sir. I have one question to you, Andy, Srinath Garu. Are you confident that every attorney did that mistake?
Look at I came around like 1,000.
I'm asking you the question, sir. You're making a very generalized, broad statements blaming every attorney.
Okay.
Is every attorney did that mistake?
Now, I said most of the attorneys. I'm saying that most of the attorneys.
I mean, how many cases have been rejected? Sir, how many cases have been rejected if that is the case? How many attorneys? That's anyway, sir. That's out of the topic right now. What do you want from me, sir? Basically, what do you want from me now?
So, my question is, how we can get when you get rejected, can we file a suit again as a CIS or to the attorney? Which way we can get the justification here?
Sir, basically, you can file a complaint against the attorney if the attorney fails to competently represent you before the USCIS. But if there's a clerical error, there's very little gain you will have by filing a complaint against the attorney. If it's a CIS error, basically, you can actually make a service request to saying that it was the CIS error. But the whole problem with these 485 filings is that even though it's a CIS error, basically, if the dates are not current, in the past practice of the USCIS, what I've seen in the past, in my 17 years of practice, basically, is that if the dates are not current at the time of you resending the file, although it's an error committed by the USCIS, they won't accept it, basically. They won't admit it was their mistake, basically. Okay? And that is the problem we have when the attorneys are acting as your agents only, basically. When they're preparing the files, basically, they will be sending the files for you, for the candidates to review the files properly with information providing that it's properly or not. You have every right as a client of an attorney to ask why this question is not filled, why it has been filled, and all those things, basically. And if you did not ask that question, you're partly responsible too, because you are signing on the form saying that the information provided by you is true and correct, right? So sometimes clerical errors, it's possible that clerical errors may have occurred with some attorneys, but it's not fair to generalize that every attorney is incompetent, basically. Because in my office, we don't have any kind of those kind of rejections, basically. We have probably 2 to 3 rejections, and those are the USCIS erroneous rejections. We are fighting with the USCIS on them. We filed probably 500 cases, basically, in October, November, and December. And the only 3 cases where we have seen that problem, where USCIS erroneously rejecting the files, basically. So generalizing statements is not probably appropriate under the circumstances, but it's your opinion, sir. And if it comes to the accepting the derivative applicants, I do not know, sir. I have to really I haven't really studied or observed the trend, basically, what US is doing, because, as I said, we didn't have much rejections, basically, so we did not resend the files that many to the USCIS, basically, especially after December 2021, And so I have no idea exactly what's going on. If these derivative applications have been filed prior to December 31, 2020, that is a possibility. If they are filed before December 30, 2020, because the dates were current at that time, so it's very likely that those cases can be accepted by the USCIS. But my understanding is that USCIS is going to issue a circular on this. Reason because we have seen some erroneous rejections by the USCIS under these circumstances, right? Like, for example, when they send everything, they miss the check or they miss one page in the form because they kept the files for 4 months or 3 months to issue a receipt in the lockbox center, basically. So there's a very good chances that they may misplace the documents and papers and everything. And the same situation happened for the F1 OPT student applications also at the lockbox. When it happened, basically, government came back and said that for F1 OPT students, that they will be given an opportunity to refile again if the file application is filed between November 1, 2020 to June 2021, basically, right? So the same thing we are expecting that in AILA, basically, many lawyers expressed, basically, in American Immigration Lawyers Association, many lawyers expressed that USCIS may come back and give some kind of a notification on this, telling that these people, if whoever's files have been rejected basically by the lockbox center, especially after 3 months after filing without giving a proper receipt, that they may ask them to refile again, basically, with proper corrections and everything, so that they'll accept the processing. That is, the possibility is there. We are very eagerly waiting as attorneys how it's going to be happening and everything on that. And if it comes to some lawyers doing mistakes, basically, I think you should talk to those lawyers and basically find out exactly why they have done that mistake and how they can help, how they can address that issue and everything. But we have like 99% cases have been selected, and we are okay. We are very happy with everything what's going on with us. So I cannot comment about what's happening with other law firms, sir, because I'm not their lawyer. I'm not privy to their information.
Yes, Bhanu, we have another caller, Raj. Raj, please go on.
Hello, good evening, Bhanu. Thanks for your time today. I'm in F1 status, and my employer has registered for my H1B lottery. Also, there is another employer, future employer, who also is willing to employ me. They have also registered for the H1B. My question is, if in case both of them get picked, and I need to submit further documents to both of them, is it fine if I go ahead and both employees go ahead and complete the filing of the H1B, or is it advisable to just do through just one employer?
Sir, if they both are two different and unique bona fide offers, and if the both get selected in the lot, basically, okay, there is nothing wrong in both employers filing an H1B petition for you, because you always have an option to choose which employer is better for you to work. So there is nothing wrong telling the both employers to file H1B for you, and you joining them once H1B is approved, basically, in that position, provided they both are unique and different and bona fide job offers. Mistakenly, if they both are filing for the same project, same client and everything, then if they are not, then they eventually, the both will be resulted in denial, basically. So you have a choice to make on that, sir. If you have any question, feel free to reach our office. We are very happy to look into it and guide you, sir. You know?
Right. Thanks for calling. And next, another caller. Yes, Raj, you have any question? Hello? Yeah, that's fine. Our next caller is Swapnil from New Jersey. Swapnil.
Hello, sir. This is Swapnil. I have a quick question. I have 140 approved from my previous employer, and now that I've changed my employer and I'm starting my green card process again, I just wanted to know, in this scenario, it might take a year or 1.5 years, depending upon the timelines. Suppose my priority date of filing USCIS accepted, and I could file my 485. So can I start my process from my previous employer? And the question goes on, like, now in future my 140 from this employer is approved, and again I changed employer. So can I go to any of the previous two employers to get my 485 started again?
Yes, yes. As long as they're willing to hire you permanently, once you get a green card, yes, they should be able to allow you. You should be able to go and file adjustment of status with them pursuant to their I-140s, provided they do provide their consent that you should be able to get a green card, that they're willing to sponsor you a green card, basically, so that you can join them permanently once you get a green card. And absolutely.
So it's not that the latest 140 approved, we need to go to them. It's any of the previous 140 approvals, I can go with those employer who is willing.
Yes, any of the employer. As long as that employer is willing to hire you permanently, once you get a green card, that is what the requirement is. And you are intended to join them permanently once you get a green card. And those two prongs has to be met and has to be proven when you file 485 to get the green card, basically. And as long as you both meet those two requirements, there should not be any problem for you going ahead and filing adjustment of status based upon those employers' I-140s.
Okay, all right. Yeah, that was my basic question. Thank you, sir.
You're welcome, sir.
Thanks for calling. And our next caller is Krishna from San Diego. Krishna, please go on.
Hello, sir. నా పేరు కృష్ణ అండి. మొన్న అక్టోబర్లో డేట్స్ కరెంట్ అయినప్పుడు నాకు, మా వైఫ్కి, మా పాపకి, ముగ్గురికి అప్లై చేశారు. చేస్తే నా అప్లికేషన్ ఏమో నెబ్రాస్కా సెంటర్కి వెళ్ళింది, మా వైఫ్కి పాపది ఎంఎస్సి సెంటర్కి వెళ్ళింది. అక్కడ మా వైఫ్ అప్లికేషన్ రిజెక్ట్ చేశారు, సేయింగ్ దట్ ఏవో పేజెస్ మిస్సింగ్ అనేసి. సో మా అటార్నీ వాళ్ళు చెక్ చేసి అన్ని ప్రాపర్గా ఉన్నాయనేసి మళ్ళీ రీఫైల్ చేశారు. దే సెడ్ ఒక నోట్ పెడతాం సేయింగ్ దట్ అన్ని పేజెస్ మేము పెట్టాము బట్ స్టిల్ రిజెక్ట్ అయిందని. సో ఇప్పుడు నా క్వశ్చన్ ఏంటంటే, ఇప్పుడు ఫైలింగ్ డేట్స్ కరెంట్ లేవు కదా, మరి దీనివల్ల ఏదైనా ఇష్యూ ఉంటుందా?
Sir, because of the dates currently, there is a risk. Actually, in that Srinath garu call about Dini gurinche, basically the same topic which we discussed, and what I said to Srinath garu in that call is that if the dates are not current, sometimes it's not possible that USS may not accept the refiling of it. Pages missing. We know that it's a mistake by the USS when they actually transferred the file from Nebraska to St. Louis, Missouri. That's what MSC Service Center is, basically, And when they forward to the St. Louis, Missouri office, basically, they might have missed some pages, but they don't acknowledge that mistake happened by their end. In general, I've never seen USCIS accepting the mistake happened by their end, unless they're local offices. Like, for example, sometimes your files are moved to the local offices in the final adjudication process of the green cards. because of some background checks or anything like that. Except those places, I've never seen USCIS generally in service centers accepting that the mistake has happened by their end. But as I said, because of this, I think your lawyers must have explained clearly that they might have misplaced the pages when they transferred the file from Nebraska to St. Louis, Missouri, basically, and accordingly, I think they should accept the filing of this petition as if it was filed during the visa numbers are available, basically, for this particular priority date. And they should make a request saying that they should put a heading also saying that attention CPU supervisor, basically attending and basically writing in bold letters and bold captions and everything for this cover letter and sending it to the USCIS is very, very important. And I think your lawyers must have done that. And hopefully she will receive a receipt. If not, then we have to wait until a date becomes current. I do not know what's your priority date is, but there are positive news coming about the visa dates moving up in front in coming bulletins. We will talk about that later in this call, but I don't want you to lose hope. Exactly, that's what I'm saying. In case, even if you don't get a receipt this time, don't lose hope. In the next few months, you should be able to file adjustment of status application for her. For her, only disadvantage, only inconvenience you will have is that you have to continue maintaining your H1B status and your wife continue maintaining H4 status until that period comes. But she should be able to join you anytime. It won't cause any inconvenience for you in the future also.
All right. Thank you so much, sir.
You're welcome, Ms. Nagar.
Thanks for calling. And our next caller is Ajay from Virginia. Ajay, please go on.
Hi, sir. This is Ajay. So I have a question, sir. So recently, last year in January, I got stamping with this client. So I work as a contractor with X client, and I got a stamping with the client. And the thing is, if I go to India in June, if I don't have if I'm not working with the same client, can I go to India and can I come back again to US?
Yes, provided that the thing here is, it is not the client. I understand what you are saying. So it is not the client, basically. The H-1B visa petition which you file for an employer, it all depends upon the employer and the validity of your H-1B visa and H-1B petition, basically. As long as your job remains the same, even though you are not working for the same client, if you're working for a different client in the same metropolitan statistical area where your initial H-1B petition was filed, and your job duties remain same or similar, and they have not changed, there is no material change in your employment, your visa is still valid. You should be able to go and come back. Even that is not the case also. Even if that is not the case also, your visa is still valid as long as you're coming back to work for the same employer with a different H-1B petition, different location, and different approval notice, basically. It doesn't have to be the same approval notice also, basically. So there are two scenarios which I'm talking about here. As long as the employer remains the same and you're still employed with the same employer with whom your visa has been approved, you should be able to come back with a new H-1B approval notice, whatever you have in your hand, and able to enter into this country at the port of entry. That visa is still valid for you.
Okay, thank you, sir.
Right.
And I have a follow-up question, sir. Hello.
Yes.
Yeah, please go ahead.
Thank you. Yeah. So one more question is like, last year in June, I filed my I-140 process, and so this is my 5th year, and my H-1B is going to expire in 22 October. So my question is like, how many days more it will take to complete this I-140 process?
Did they file I-140 for you already, or they did not?
They already filed in last year in June.
I mean, you should hear anytime from them now, because it's been almost 8 months, 9 months. That's the processing times right now. I think you should be able to hear from the USCIS anytime now to get this I-140 adjudicated. Maybe if they issue any RFE, it may take a little bit more time. If they have not issued any RFE, you should get the decision anytime now. You can always convert your I-140 into premium processing if you would like to, and file for premium processing in I-140, and you can get the approval basically soon. And as you said, as your I-140 is already filed, I think you should not have any problem getting your H-1B extensions beyond 6 years in October 2022.
Yeah, but my employer is saying if we go with the premium process, mostly we get RFE. That is what she said.
Yeah, I mean it's not necessary. See, anytime you can get an. I'm sorry, my glasses were a little bit this thing. Anytime you can get an RFE, Mr. Ajay. I mean, it is not that you won't get an RFE if it's a regular processing case. You'll get an RFE if it's a premium processing case. So it is all about the matter of requirement and necessity and convenience. And talk to your employer if they're willing to convert into premium processing. Take a risk of getting an RFE, even if that is the case. And if you can't wait for a long period of time, then just go ahead and file it and convert it into premium processing, and see whatever happens. You know?
Right. Thanks for calling. And next we have another caller, Akshay from California. Akshay, please go ahead.
Hi, are you able to hear me right?
Yes.
Yeah.
Hi, thank you for taking my call. So I have a question with respect to, like, my wife is currently on F1 student visa and on 2 years time extension till Jan 2023. Currently she is working and she wants to do her PhD, which is like she's targeting like next year. And the main question is, like, will there be any visa problem once she get admission for PhD? And like, how long will her F1 visa last for? Her F1 visa is like about to expire like next year. And as we are married, is it a good idea to stay on F1 or to transfer to H4?
I don't see any problem, sir, continuing on F1 visa if she wants to pursue PhD in this country. Okay? And as you said, F1 status is the duration of status visa, basically. What does it mean is that as long as she continues studying in this country as a full-time student on F1 visa, she automatically maintains her F1 status in this country. Even though her passport and the visa expires, as long as she does not travel abroad, she'll be able to continue her F1 status, provided she is actually enrolling in classes as a full-time student continuously until she completes her PhD program. Only thing is, when she goes abroad after 1 year, after her visa is expired, then she may have to attend for the interview again for the visa and then apply for F1 visa again and then come back. But if she can prove that she actually studying continuously with the current degree program and also PhD continuously, and if the program is a very genuine program, she is not continuing PhD just to work in this country, but to actually really for the purpose of doing some research, then if she can prove that, and she also proves that she intends to come back to India once she completes her PhD, she should not have any problem getting F1 visa stamped at abroad. See, my question is this to you. My solution will be this to you, basically. If she travels after 1 year and she has to go for a visa stamping for F1, and she has a PhD program at the time, and if her visa gets rejected, she always has an option to apply for H4 at that time, and she can come back on H4 over here and pursue her PhD on H4 again, basically. So I'm not too much worried about her situation. I think you should be okay. That's what I feel like, at least.
Yes. Thanks for calling. And we have next caller, Nitin from Florida. Nitin, please go on.
Hey, hi. I have a question regarding the 240-day rule for the visa holder. So is it applied for only H1 or it is for H4 also? Because my visa is approved, but my wife is pending. So do they have to travel to India after 240 days, or how does that actually happen?
No, the 240-day automatic work authorization rule is applicable only for H1B extension petitions, basically. It is not applicable to H1B change of status petitions or H1B new change of employer petitions or a new H1B petitions, anything like that. It is only, or even to the amendments also. It is only applicable to the extension petitions, basically. It is not applicable to H4s. This is 240 rule is pertaining to the work authorization, not pertaining to somebody who's authorized to stay in this country. If somebody's H1B is pending, extension is pending in this country, even if it's pending beyond 240 days, they are authorized to stay in this country, but they cannot work beyond 240 days upon expiration of their status, basically. Okay, that is only applicable to H1s, not to H4s. So if your wife's H4 is pending for more than 240 days, and if her H4 extension filed timely prior to the expiration of her status, she is authorized to stay in this country as long as the H4 extension application is pending with the USCIS.
Right. Thanks for calling. We have another caller, Rahul from California. Rahul, please go ahead.
Good afternoon, sir. My question is specific to this green card, priority dates. And I know, if there are any unused green card numbers from EB2 or EB3 category by rest of the world, they are usually added to the India, right? Like the most retrogressed country. So my question is, when does it happen? Do they do it in the same fiscal year or in the next fiscal year?
It usually happens in the next fiscal year. For example, now what they said is that the recent discussion by Department of State official is that what he said is that there are many unused family-based immigrant visas in the fiscal year, in the current fiscal year as well as in the past fiscal year And because they're not issuing family-based immigrant visas as many as they were issuing in the past, because they left over, the law requires that those visa numbers must be allocated to the employment-based immigrant visas, And that's where it's going to happen. They said that those visas are going to be applied in coming month visa bulletins, in the coming months to the employment-based categories, and accordingly, they're going to adjust the visa bulletins. And therefore, we can see a significant and rapid movement in the priority dates moving forward in the EB2 and EB3 category in coming months. I think we're going to see significant movement in the May bulletin. Already, April bulletin has come. We know that in April bulletin, EB2 category final action date has moved to May 2010. And for the EB3, it has been moved to the September 2010. So there's a significant movement. There was almost a 6 months movement from March to April. So we're expecting that it's going to be at least the same or even a little bit more in coming May month, with the final action dates. So there are a lot of positive things are happening with the Department of State because they have to allocate these visas to the employment base as per the law, and which they are going to do. So we will see that
Right.
Okay,
We
I have one more
another
question.
Yes,
Yeah.
please go ahead. Rahul.
Sorry. One more question. It is regarding H4EAD. I know, recently USCIS mentioned about premium processing for H4EAD. So I'm not sure if it's still, if it has been, started, or is there any ETA or any expected date for this premium processing?
It has not started yet, but what the law allowed is that law has given 180 days for the USCIS to formulate the regulations and formulate the policies on how they're going to start the premium processing, how many days they're going to implement for each and every type of a case, adjudicating the cases in premium processing and everything. And the USCIS still has, I think, 1 month time to come back and provide those kind of regulations, or those kind of notifications, when they're going to implement this premium processing for each and every type of a case, I'm very confident that we will hear the premium processing very soon for the H4s and other type of cases, probably in June. That's what my expectation is, but we have to see. But very likely in June, we will hear something about that from the USCIS.
Right. Thanks for calling, Rahul. And next we have another caller, Karan from Boston. Karan, please go ahead.
Hello, sir. How are you?
I'm fine, thank you, Karan.
Can you hear me?
Yeah, I can hear you.
Yes. Hi, great. So my question are actually two questions. So one is, I'm currently on H4EAD status, which is going to expire March 31st. So my company has advised me to go on LOA, unpaid leave of absence. Now my question is, will USCIS have an issue if my company puts me on unpaid leave of absence after my EAD expires, but also pays accrued PTO days, which are say vacation, sick, and personal days, about 1.5 months, on a biweekly basis during the unpaid LOA period? Is that, legal? Am I, or my company is legally doing the right thing? Or because these are accrued PTO time, which I've accrued when the work authorization was valid. It's not after the fact, it's before the fact. So is it okay if they pay me during that unpaid LOA period while I'm waiting for the EAD approval?
legally speaking, they should not employ you once your work authorization is expired. Okay, and see if there are any arrears which they can pay you for the unpaid leave of whatever the accrual of the leave you have, basically, and then if they're paying you for that after you resign your job legally, that's okay. But that's for the previous period, but not for the existing period, basically. Okay. You and your employer may have an agreement saying that you're going on a leave of absence without pay for a certain period of time until you get your EAD. But legally, you are no longer their employee. You should not be employed with them. But they can pay you wages during that period for anything that are arrears due for the period which you were employed with them. Hope you're understanding what I'm saying.
Hello?
I think he's
yes, lost. Right. Thanks for calling. Next, we have another caller, Bhanu Garu. Karthik from Louisiana. Karthik, please go ahead.
Hi, can you guys hear me okay?
Yes.
Yeah, thank you, Andy. I have two questions, Andy. One question I'm asking on, family behalf because, it's hard to get on the line. His question was, he was working for an employer A last year in 2020, and his contract with that employer A ended in April 2020. So he switched to employer B, and employer B filed for his H4E visa transfer in April 2020. And ippatidaka tanaki he didn't get the H4E transfer approval yet. Though it's close to a year, they didn't do the premium processing yet. I don't know for whatever reason. And recently, just to be on a safe side, he filed for another transfer with employer C on the previous H4E. So he wanted to know, is this even legal? Is he even staying in the United States in a legal status right now? Just because when he checks the USCIS website with the receipt number for the employer B petition, it still shows that it's pending, and the employer C they just upgraded him to premium and he got an RFP. So does it mean he is in legal status, or
he may not have a legal status, but he is authorized to stay in this country and authorized to work pursuant to the H4E portability laws, basically under AC-21 Act. Okay. What does it mean is basically is that if somebody files for a transfer, they're authorized to work with the transferring employer because under the H4E portability rules. It doesn't mean that H4E has to be approved for them to start working with that employer. Here, he is authorized to work with employer B because of the petition filed by the employer B at that time, basically. And he's authorized to work for unlimited number of time as long as the petition is pending with the employer B. Okay? And at the same time, actually now he moved to employer C, and he is authorized to work with employer C. But the problem here is the petition filed by the employer B acts as a bridge petition for him. Okay? And of course, because it acts as a bridge petition for him, the RFE might have come asking to show whether he's maintaining valid legal status in the US or not, because employer B petition has not been approved yet. USCIS might come back and ask for that. So here, there is only one exception to the rule that under the bridge petition, that if the employer B petition is approved, then only employer C extension of status can be approved, basically. If employer B petition is denied, then employer C petition, if they requested for the consular processing, then the extension of status will be denied. But if the petition is approvable, then they'll approve it to the consular processing. But there is one exception to this. Under the 2016 regulations, there's one exception to that, where is that if the employer A petition is still valid as of now today, okay, and if he hasn't used any grace period in that period, basically, the lawyers with the employer C can make an argument of the grace period availability to him, therefore is eligible for the approval of extension of status, basically, with employer C. Because the regulations give one exception when a 60-day grace period can be available to one person. That exception can be used over here. It's a little bit more complicated technical issue. I do not know whether I can explain this in the call. I can explain that, but it takes time for me to do that. There's one exception in the regulations given in the preamble of the regulations passed in 2017, 2018, where 60-day grace period is come into effect, basically saying that if especially in the H1B transfer positions, basically on a case-by-case basis, it says that USCIS can consider if somebody did not use the 60-day grace period when they transfer to employer A or from one employer to other employer, and if something happens to the petition filed by the other employer, and if they move to third employer, basically, if the petition from the employer A is still valid, they should be able to, and if that within the 60-day grace period, if they file for it, after the denial of the employer B petition, they're eligible for the 60-day grace period and able to get H1B approval. We basically use this argument all the time under these bridge situations, basically. So if that exception is available to him, basically, if that exception is available to him, then there's a possibility that it can work for him, basically. Okay. Otherwise, he may have to go to the consulate, get visa stamped, and then come back to the US. I'm not sure whether I've been clear here or not how this 60-day grace period exception works here. As I said, it works on a case-by-case basis, and their lawyers should be able to make that argument if he hasn't used the 60-day grace period when he moved from employer A to employer B.
సో భాను గారు H1B అనేది చాలా మంది డ్రీమ్ కదా, అండ్ మిషన్ H1B లో ఐ థింక్ ఫస్ట్ స్టేజ్ కంప్లీట్ అయింది అనుకోవచ్చు. సో సిన్స్ ద రిజిస్ట్రేషన్ పీరియడ్ ఈస్ కంప్లీట్ అండ్ దెన్ లాటరీ ప్రాసెస్ అండ్ రిజిస్ట్రేషన్ సెలెక్షన్ డెడ్ లైన్స్ ఎలా ఉంటుంది, నెక్స్ట్ ఏం చేయాలి అసలు?
ఓకే అండి, as we all know that for fiscal year 2022 registration is completed yesterday noon.
Yes.
Basically now, as per the USCIS guidelines, they are going to announce the lottery. I mean, which case have been selected in the lottery by March 31, 2021, basically. Because the fiscal year filing starts from April 1, 2021. Therefore, they have to complete the lottery process by March 31, 2021. So every employer, basically, whoever actually registered for their employees, make sure that they look into their emails, basically, whether the case have been selected or not. Or they can even log into their portal, basically, USCIS portal, into their accounts and see basically which case have been selected, which case has not been selected, and everything. The best way to know that whether the case has been selected or not is there will be a status button in the portal, like in the account portal. That status button will change whether it's been selected or whether it's been rejected or it's been submitted. If it's still in the submitted category, that means not selected. If it's selected, then it's selected, and those individuals are eligible to file for H1B petitions, basically. Last year, they have given 90 days time to file the H1B petitions once the case has been selected in the lottery. The 90-day period starts from April 1, 2021 and ends on June 30, 2021. This year also, it's going to be the same, and that's what it's going to be. So all the cases that have been selected initially, basically, they will be required to file H1Bs from April 1, 2021 to June 30, 2021, with effective start date of October 1, 2021, because fiscal year start date is October 1, 2021. If they miss the boat, then they'll miss the opportunity. And it all depends upon how many cases have been filed between April 1 to June 30, 2021. And if they did not receive the required number of applications, that is 65,000 plus 20,000 applications by June 30, 2021, probably they may open up a second lottery, second round, just like how last time happened. But my anticipation is, even though there's going to be second round, there is very likely that there's going to be second round this time also, but the numbers will be very less compared with the last year in the second round to be filed. And again, for the second round, they're going to announce basically what will be the period of 90 days they're going to accept the filing of the H1B petitions and everything. So this is the process which they have to follow. So all of you, we are just holding our fingers right now, crossing our fingers and keeping how many people will get selected and everything, because we do not know total number of registrations, how many happened and everything. But the way we have seen the rush for the registrations this year, we are anticipating more than 350,000 cases to be registered, at least 350,000. Even if we reach 400,000 mark also, no surprise, basically, So that's where it is, Andy. So now, I think from tomorrow day after tomorrow, they need to start looking into their accounts, looking into their emails, basically, because by March 31st, they will notify everybody whose case have been selected, whose case have not been selected, Andy. And they'll have 90 days time to file H1B petition. Make sure that H1B petition is properly filed, properly prepared by the attorneys. If you don't have an attorney, if you're filing by yourself, make sure that you meet all the requirements, make sure that all information is provided in the H1B petitions basically. And H1B petition has to have a starting date of October 1, 2021. And then you file the H1B petitions by June 30, 2021.
Right. Thank you so much, Bhanu Garu, spending your valuable time here. And thank you. Thanks for joining us.
Oh, thank you very much. It's my pleasure to join Always Prasanna Garu. And thank you, Sakshi team, entire team, giving this opportunity for me every week and talking about the US immigration laws, basically. And very happy to become part of that. And thanks once again for inviting me for the show, Auntie. Thank you.
Right, thank you. Right, ఇది వాళ్ళ స్పెషల్ ఇమిగ్రేషన్ షో విత్ అటార్నీ భాను బి ఇలింద్ర గారు. నెక్స్ట్ ఎపిసోడ్ లో మరింత అప్డేట్స్ తో మళ్ళీ కలుద్దాం. స్టే ట్యూన్ టు సాక్షి తెలుగు ప్రజల మనసాక్షి. నమస్తే.